I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class about the classic canon of construction called Ejusdem Generis, which I have subtitled, "One of these things is not like the others." Now, a quick word for my class before we proceed. The canons of construction are studied in a section of our casebook about interpreting statutes or construing. When we talk about construction, we're not talking about putting up buildings. We're talking about canons for construing certain types of clauses, especially these stock phrases that come up again and again in statutes, and how we're going to construe those when we have to apply a statute in court. They can get confusing, especially the ones with Latin names, or in this case, an old legal French name, old French name. And when in practice, you don't have to call them that. You can use a modern English phrase instead to describe the same phenomenon. Of course, there's controversy about these. There's plenty of law professors and lawyers who think these are all a bunch of bunk and contradictory and so forth. I actually think that they're useful for sort of describing nuanced things that we're doing with statutory text. They can help you identify subtle structural features in a statute that really affect the interpretation and zero in on what that clause or feature means, and try to create, and these canons are then sort of kick it up a level of abstraction to having a general rule for what we do with these sort of stock phrases or building blocks that are common features of the genre of literature that we call statutes, right? The form of writing of modern statutes. So let's go in here to talk about this canon. And by the way, I'm going to draw some quotes from the classic treatise that's very prestigious on statutory interpretation and construction, which is Sutherland's. And I have a reference in the side on the picture. Ejusdem Generis literally means of the same kind. That's what the old French phrase means. But the maxim in practice today really means that where you have a catch-all phrase at the end of a statutory section, it's usually they say something like, comma, or any other blank. And so in my class, we read the case Circuit City Stores v. Adams, where it's, or any other worker engaged in commerce or interstate commerce. But you could have criminal statutes that say, comma, or any other weapon, or any other injury, or any other victim, something like that. But these are catch-all phrases, usually following a list of specific words that delineate the statute's coverage, let's say. And if so, then this general catch-all phrase at the end only applies to items with the same common trait or feature as those specifically mentioned in the preceding series. In other words, you have to look at that list and ask yourself, is there a shared trait or a common denominator? And if so, the phrase or any other, we're not going to apply this absolutely that now the statute applies to everything in the world or in the universe. Instead, it applies to other things of the same type or category that have that shared trait, the same shared trait that the other specified items share. So it might help, I think it helps me, to analogize it to that childhood identification game. One of these things is not like the others. I grew up watching Sesame Street, and they had a skit in almost every episode where they had this little song. It was always the same song. One of these things is not like the others. One of these things just isn't the same. And they would then put up like 4 squares with these pictures, sort of like the one shown here. And you were supposed to, as a 4-year-old, figure out which didn't fit. And hopefully you're paying enough attention that you picked the shoe. The shoe doesn't fit. If not, you not only need to rewatch my video, you need to rewatch Sesame Street. So the courts invoke the canon Ejusdem Generis to eliminate possible meanings of words that are not like other delineated items in the clause right before it. So in other words, the range of all things that could be included under a phrase or any other blank, we're going to narrow the category of possible applications and to fit with the others that we have. Or to go with the picture here and play our little game, if we had a statute that said hammer, pliers, saw, or any other tool, that shouldn't include shoe. Now, could you make a far-fetched argument that shoes are tools? Sure. And I mean, maybe it's a tool of your trade because you're a marathon runner, or maybe when all else fails, when your hammer breaks, you just hit things really hard with your shoe. I guess it's possible. Certainly people have tried to hammer things with high-heeled shoes with the heel, but really it doesn't fit in the category. Nobody thinks that the legislature meant to include shoes in a list that's hammer, plier, saw, or any other tool. And that's what we're talking about with this canon. Some of you are thinking, oh my gosh, this is just common sense. Why do we need a French phrase for it? That's sort of, over the top. Sure, then just argue this as a matter of common sense. But the phrase ends up being shorthand for a really, for me rambling on and on and on about Sesame Street, right? It's much easier to just quote, have a nice 2-word phrase you can spout off to the judge. So note here in practice, when you're a lawyer, the effect of applying this canon will always be to narrow the scope of the statute or its range of application, or at least that clause in the statute, because it takes the general catch-all phrase and narrows it to items that share a common denominator or trait with these specifically mentioned items. A lot of our canons actually are really doing this kind of work. They're either giving the court a quick way to broaden the scope of a statute or narrow it. These catch-all phrases at the end of statutory provisions are a very common drafting feature of statutes. And there's a sense in which it saves the legislature from spelling it out in advance every situation or contingency that the statute could apply to, right? They don't have to list everything. And we have another canon that says if they make a list and don't include one of these catch-all phrases, then we assume it doesn't apply to anything else. Also, keep in mind that common law courts didn't really have to interpret that many statutes by comparison to modern courts. Statutes proliferated rapidly after the Civil War and into the 20th century. And so courts started to encounter some of these stock features of this that come up in almost like there's a template to statutory drafting, and courts started encountering these catch-all phrases more and more and have to have a tool for dealing with it. Keep in mind that this limiting canon restrains courts. It's not just restraining the legislature, it's restraining courts from applying statutes too far or too absolutely. And if it's a statute that's a regulatory enabling statute, in other words, for an administrative agency, using this canon can rein in the jurisdiction or purview of an administrative agency, which is something to think about. Also note that because the canon effectively narrows the applicability of a statutory provision, it usually benefits one litigant over the other. So these are not just philosophical questions about meaning. Applying a canon or not is usually favors one side and disadvantages the other litigant. So one side is usually going to say we should follow this canon, and the other party saying don't. Okay, here's a gotcha. You need to watch out for this. Pay close attention to whether the or any other blank phrase is in a clause that describes the statute's main, like general scope or coverage, like the main body of the statute, or if it's at the end of an exception provision. Again, in that case, in my casebook that I use in my class, Circuit City Stores v. Adams, the or any other blank phrase is at the end of an exception. So if it's at the end of an exception, this broadens the exception. The phrase or any other blank broadens that exception and thereby narrows the range of the statute. So in the case I mentioned was about the Federal Arbitration Act, and the employee didn't want to go to arbitration. They wanted to get out of binding arbitration and go to court. And so they were trying to stretch the meaning of an exception in the statute to apply to them so that the statute won't apply to them. And so the broader the exception, the narrower the applicability of the statute, and vice versa. And so then if we bring in Ejusdem Generis to narrow that exception, we have then broadened the range of the statute. And that's what happened in this case. In that case I mentioned, the court applied Ejusdem Generis and said, you're out of luck, employee. You have to go to binding arbitration. The statute does, in fact, apply to you because we used Ejusdem Generis to narrow the effect of an exception, and that broadens the range of the statute. This is the tricky part. And so make sure you, if you need to pause the video and read this slide and think about it for a minute, you should do so. This is where you could get tripped up reading a case or in practice. Okay, that concludes our lecture about Ejusdem Generis.